All right, Mr. McFerrin, are you there?
Yes, Your Honor.
Okay, and Mr. Powell, if you can unmute yourself, please. Mr. Powell, are you able to hear me?
Yes, sir. Can you hear me?
I can, okay. And Mr. Blumberg, are you here on behalf of JAM Exploration?
I am. Mr. Chappell, representative, is in my office as well.
Okay, and then ma'am on the iPhone, can you unmute and tell me your name, please?
Hi, this is Natalia Powell.
Okay. And then we have Mr. and Miss Guyana also present by Zoom video. So we'll go on the record. This is McFerrin versus Powell et al. This is case number 2218941. We're on the record here today for a couple of different matters. Mr. McFerrin has a motion to disqualify me as judge in this file. Mr. Powell filed a motion to dismiss. And then we have this set just for a status conference. Mr. Blumberg, is your client taking any kind of position with regard to the motions that are up for today?
Well, Judge, the parties don't send me copies of anything they file with the court, so I haven't had a chance to respond. I did receive Mr. McFerrin's motion. I don't know anything about any other things that have been filed.
Okay, and I understand we've got, I think your party's the only one that's represented here.
Yes.
So the court's also had some issues in terms of court rules and filings with all the parties. So I think what I'm going to do is go forward with the motion portion of this. Mr. Blumberg, I don't know what position you're going to want to take after you hear what the parties have to say, but I guess we'll hold off on that, and then I'll let you make whatever record you want to make in terms of what the court should do.
Okay.
As it relates to your client. No other parties filed any responses. So let's start first, Mr. McFerrin. I did receive your motion to disqualify. Is there anything that you wanted to state for the record in addition to what's in your motion?
Your Honor, I believe it's probably your first time seeing surveys that have come before you on other court appearances. And that's pretty much where we'll leave it. If you're planning on recusing yourself, then there's no reason for me to argue, I do believe.
I'm not planning on doing that, but today's your chance to put your arguments on the record for why I should do it.
Oh, Your Honor. Well, the reason, one of the number one reason is you're going to be a witness. You're a material witness for myself. A lot of this pertains to access of easements, and we're having issues with the PPOs, with the eyesight. There is no way that we can access our property without violating your PPOs, which is an issue. And if you look at some of those surveys, cabins and buildings have been placed 6 feet off the roadway. We have some of your PPO holders being charged with false police reports. We have questions about them falsifying Judge Cooper's orders. And he's going to be a witness as well. And so you are the best individual to speak on how we're supposed to access this property without violating your PPO. And so that's why I'm going to ask you for the main reason to disqualify yourself, as everyone keeps reverting back. And as far as everyone, I mean the defendants, Powell's and Guyana's, keep referring back to this PPO, and you're the best one to speak on it, Your Honor.
Okay, all right, thank you. Any other argument you wanted to make on the disqualification part of this?
We've had some ex parte communications. It seems like Mr. Powell has sent emails to the courts in previous court cases, and some of the other court testimony with some of your court transcripts, it seems to be there's individuals coming into the courtroom and speaking to you outside of court proceedings. So we'd like to take that in consideration as well. And it's highlighted there in those court transcripts.
What transcripts are you talking about?
It would be to the transcripts of Officer Taft when Mr. Powell didn't show for court.
So those aren't, that's not a transcript. A transcript is a recording of what happened in open court. So are you talking
Yeah,
about transcripts or are you talking about something else?
No, it's the transcripts included in the motion that are highlighted. Michelle Davis is the one who recorded them as well. She put them into Word format from audio to paper.
Okay, all right. All right, thank you. Mr. Blumberg, does your client take any position on the disqualification?
Well, Judge, I'm fairly familiar with the court rule and what's required in terms of affidavits. And I think within 14 days of determining there's even a basis for filing a motion, that has to be filed within that time frame. I don't know anything about Mr. McPheron's allegations, so I know that there's a requirement to demonstrate actual bias or prejudice, and I haven't certainly heard anything that would suggest that.
All right, thank you. Mr. Powell, did you have anything to add on just the disqualification issue? I know you got your motion and I'll ask you about that next.
No, sir, I had a chance to review it. I have nothing to say about it. I just believe that a lot of it referred to things that have already been adjudicated from previous cases. I didn't see anything there that would be an issue.
All right, thank you. Ms. Powell, did you have anything you wanted to add with regard to the disqualification issue?
No, Your Honor.
Thank you. Mr. or Ms. Guyana, was there anything that either of you wanted to add on that issue?
I disagree. I'm trying to get you off of this case. You've been fair.
All right, okay.
I don't know nothing about them.
All right, okay, so the court will issue a written order with its decision on the motion to disqualify. I am going to make a record though, because I think this needs to be said. Mr. McPheron, I don't know what you're referring to, or even if you're, if you fully understand what ex parte communication means, but it has a very specific meaning within the law, and it refers to communications that are had off the record with only one party involved. And I'm going to state for the record here that I've had no ex parte communications with any litigant in this case. The only communications that I've had are either those that parties have filed in writing, and those are all in the court files, or communications that have been on the record here and recorded for everybody to hear who wants to show up. So to the extent that you're alleging that I've had some kind of inappropriate discussions with people outside of court about this case, number one, it's absolutely not true. And I don't think there's any basis for that. Your arguments with regard to potential witness are things that I'll deal with in the written opinion, but I want to make it clear for the record here today that I've had no inappropriate outside conversations with anybody related to this case. But moving on then to Mr. Powell, to your motion to dismiss, is there anything that you wanted to state in support of that?
I'm sorry, Judge, could I just interject for a moment, please?
Sure, yes.
I think procedurally, you probably shouldn't be ruling on any of these other motions until you've decided the disqualification motion.
I agree, Your Honor.
Yeah, and I absolutely agree as well. That's why I'm going to issue written opinions as to all the motions today. I'm not going to rule today. I'm simply going to take oral arguments from the parties and then issue a written ruling as to all issues later.
Okay.
So Mr. Powell, if you'd like to go forward with your argument.
Yes, sir, Your Honor. So the basis of this motion, so this case was filed last year in May. At that point, he had an attorney, the plaintiff, McPheron, had an attorney that was representing him. During a brief exchange between his attorney and I, there was paperwork indicating, well, first of all, I was served with his suit with a bunch of allegations that lead nowhere except one's imagination. What I have and what I had sent the plaintiff were police reports that have been made by me starting in December of 2020. Accompanying that report, there's this DVD or cell phone video footage that apparently Mr. McPherson and his attorney at the time, Mr. Ingleson, claimed was never submitted as evidence. They claimed that I destroyed the evidence, which would have put me in the hot seat when it was specifically requested by the prosecutor and the police department, because I mentioned that there was cell phone footage taken of the incident that occurred on 12/24 of 20 involving the plaintiff and I. I strongly believe that the information that is contained within that DVD or cell phone footage, along with the police report, absolutely refutes a very large portion of those allegations that were brought against me in that lawsuit. Now, interestingly enough, I didn't have a problem FOIAing that information. Okay. It is on record. It is on file at the sheriff's station that I had filed several FOIAs to get copies of that DVD. However, I do want to mention what I did find regarding that DVD. I think where Mr. Ingleson was confused by is that when Mr. Rolla took office, I believe
Your
it
Honor,
was January.
Mr. Ingleson has no relationship with Mr. Powell. Mr. Powell,
Mr. McPherson, hold on a second. Okay, this is not going to be an open like debate or dialogue. Everybody's going to have their turn. So whatever you need to say, I just need you to make a note of it, or whatever you need to do to remember so you can address it when it's your turn. Okay, but please don't interrupt.
Yes, Your Honor.
Thank you. Go ahead, Mr. Powell.
Yes, sir. So what I submitted to Mr. McPherson was a copy of the DVD, along with the police reports that were made. I made 3 police reports, 2 in which Mr. McPherson was arrested by the police, the sheriff's department, when they responded to our location. I don't determine police investigations or how they investigate. I just tell them the circumstances of the incident. They're the ones that decide whether somebody's arrested or not. I was repeatedly accused by Mr. McPherson and his attorney at the time of making false police reports. I also want to add, on the 3rd police report that I made, there was a court trial involving Mr. McPherson and possible PPO violation, in which subsequently he was found guilty of civil contempt, not criminal contempt. So with that being said, the 3 police reports that I made can speak for themselves regarding accusations in the suit by Mr. McPherson and his attorney at the time, in which they accused me of making false police reports, false statements. I requested any and all information regarding the incident, holding the plaintiff to his proofs. I requested any and all information in the forms of witness statements and police reports that he may have made against me, booby trapping, easements, blocking easements. Again, we have to remember there are other property owners that are north of us. There's at least 2 or 3 that I know of, and it's just very suspicious to me that it just seems like it's just this corner that's creating the source of tension on the plaintiff's behalf regarding an easement, right away, trespassing regarding his property. There's been 2 surveys that I know of, not including the original one that the landowner had done, and they all say the same thing. When I bought this property, when I leased this property, going back to late 2016, I was given a survey sheet by the landowner upon purchase. It spoke for itself. It was very clear to me what my property lines were and what the property lines were to my abutting, the neighbors that abutted to my property. So that incident that took place in December of 20, there was a confrontation. Again, the DVD, the cell phone footage that I submitted to the courts, and the police report speaks for itself. And I'm constantly being made out, according to the lawsuit, as making fraudulent statements, doing sneaky things behind the plaintiff's back to upset him. I submitted to the courts, along with this motion, everything that I had submitted to the plaintiff. Again, the plaintiff hasn't sent me not one bit of evidence pertaining to the allegations in the lawsuit. I'm not talking about anything else. I wanted specific proofs that stated there was a photograph of me, video, witnesses that could back up any of the claims that were made, police reports that were made against me, whether they were substantiated or not. I have received, this is over a year, and I've received nothing. And one particular allegation in the lawsuit, in which I'm being accused of committing a felony. And again, the video speaks for itself. Who was arrested that day based on what evidence? What did the deputies find as evidence? It speaks for itself. It's not complicated, just like these surveys back here. It's not complicated unless you make it complicated. Everybody else that has property back here seems to get along just fine. In fact, where I'm located, it happens to be in a very rectangular formation that backs up against a corporation's property. And I'm kind of separated from everybody else involved in this litigation by it's the same easement, but it runs different directions. And again, for some reason or another, it seems that the plaintiff has always took issue with that. And here we find ourselves, all these years later, not talking, Your Honor, 2 years ago, or 2 years after I purchased the property, 3 years after I purchased the property. It was only after all these issues were concerning the plaintiff and the Guianas regarding property lines and surveys. Did attention get directed towards me? You got to remember, we've all had these properties roughly since around late 2016, 2017. I didn't even know the Guianas at that point as well. Either did I know Mr. McPherson, but I knew that there were some pending issues regarding property lines and surveys. But why is it I've been here since 2017? I didn't even make a police report against Mr. McPherson until the incident of 12/20. Anything previous to that, I practically had no contact with Mr. McPherson, except for the occasion, meeting him at the mailbox or on the passing. And we would rather not communicate than to communicate, because I didn't want to get involved in property issue disputes, et cetera, et cetera. And as far as the PPO is concerned, I have no idea where the plaintiff is going with this, because the way I understood it, the PPO that was extended when he was found guilty, the plaintiff was found guilty in June of 21, I believe, was to finish out its term that following December. And there was an order that was given, if I recollect properly, that it was to be dismissed that December. So that would have been, now we're going on almost year and a half, 2 years. There has been no issues since then. I've had no police reports to make since then. And even when the PPOs were valid, yes, we have to, there are the occasions in which we have to pass each other, see each other at the mailbox, et cetera, et cetera. There has been no conflict. Can you imagine how many times we've probably had these little by chance meetings in a 7-year period? I would think they're probably too numerous to count. There's never been any problems, and I'm certainly not the one to make a complaint every time I seen Mr. McPherson, because I have 2 children to take care of. I have a sick mother that's disabled that lives here with me since 2017 that I take care of. I have a 70-year-old mother-in-law who lives here, and my wife is here. I got better things to do than to worry about McPheron's problems, only that he's making problems and he's got nothing to substantiate anything in his claims other than they're malicious, they're harassing in nature, and it's just a vendetta drive to bring everybody else down. And the only way that I understand it is that initially when I was served with the lawsuit, my wife was served with the lawsuit, there was an amendment made shortly after that. And then everybody else was added along in with it. What's the motive behind that? I have no idea. But the only thing we can go on is records that were made, a paper trail, police reports, etc. Where's the police reports that were made against me for any wrongdoing that I've ever committed? In fact, how about the landlord? I mean, if you're a renter of a property, for instance, if you have a problem with your neighbor, you're generally going to call landlord. You're generally going to report some wrongdoing. I wonder how many times I've ever called the landlord, or excuse me, Mr. McPheron's ever called the landlord to complain on me about anything that I've ever done, that the landlord felt substantiated enough to come and correct me regarding any of my wrongdoing, any of my wife's wrongdoing, my children's wrongdoing, anything that my 75-year-old mother might be doing wrong, or even my 70-year-old mother-in-law. How about my wife, not to mention? Maybe because she leaves and she has to pass the easement.
Okay, Mr. Powell, I think we're getting a little far afield here. You know, this is a legal issue, and I understand you've got some frustration there. I think.
Yes,
So,
sir. Yes, sir.
Is there anything more you want to say with regard to the legal issues here?
Nothing more other than what I submitted to back up my motion.
All right, thank you, Mr. McPheron. What did you want to say in response to Mr. Powell's motion?
Correct. Well, Your Honor, as we just witnessed, Mr. Powell brought in the PPOs numerous times. So that's why we're subpoenaing you as a witness. Mr. Powell's my original arrest revolved around, the survey was submitted, the stakes in the easement. Come to find out when we went to court, which Mr. Engelson sent the survey to Mr. Fenton. It was found that the stakes that were placed in the roadway were merely at minimum a zoning violation, if not a criminal violation, which that's why the case was rescinded for criminal damaging, because the stakes were placed in the roadway. And according to the prosecutor's office in an email sent to my attorney, said they were unable to retrieve the cell phone video off of Mr. Powell's phone. And that's dated in April, and his police report is dated in March, and his police report lists parts of the video, not all of the video, by Officer Tubbs. And then the Officer Taft arrest involved us just merely using the easement to go to our property, which was a line of eyesight issue. So we'd like to just put that on the record that we were arrested for merely driving by Mr. Powell's home. And his home, according to his own permit chart, is 100 feet off the roadway to 120 feet off the roadway. As Mr. Powell alluded to, it's impossible to not appear within his eyesight and violate a PPO, which violates my access to my properties, as I've been fined at $800 for driving to my home. So that's all we want to put on the record, Your Honor.
All right, thank you. Mr. Blumberg, anything you wanted to say on this issue?
Judge, I wasn't even provided a copy of the motion, so I'm assuming it's a summary disposition motion, a motion to dismiss.
Correct.
I have no position. Again, I wasn't even provided a copy.
And Your Honor, if I may, that dismissal was sent to the wrong address as well. My address is listed as 710 Willard, Lima, Ohio. I've currently listed the properties up there to sell and have been trying to sell them for the last year. And so we have this easement issue where it's tough for us to sell this property with these easement access issues. In fact, we listed the property a month ago and several individuals called the realtor, and we had to pull sale off the market or pull the property off the market. So we are trying to vacate the area for the court record.
Okay, all right, thank you.
If I may add to that, that's pretty critical. So, the plaintiff has been using 2 addresses. I got paperwork from him that lists his address at 6127 Screaming Eagle here, and court paperwork from him that lists the Lima, Ohio address. And so during the interrogatory phase, I asked the plaintiff if he receives mail here on the Screaming Eagle address, and his reply was yes. So I don't know if it's a matter of trying to, dodge and duck, or if it's, even if he knows what address he has, but legally you can only use one. But I do have court paperwork just a few months apart with his name and address on it as given both addresses. Just wanted to make that. And I also have a supplemental regarding the cell phone footage that is listed with the original, that it was quoted by Jones on the above date and time. I received cell phone video footage that N. Powell had recorded showing parts of the altercation between G. Powell and McPherson, not parts of the DVD, parts of the altercation, because when an altercation happens, it usually takes a few minutes to process or whatever before you can figure out, hey, this is really what's happening. We need to get something on video here. So there is a supplemental from Deputy Jones received by Deputy Joshua Tubbs. My mistake on that. Indicating date and time, which is March 31st, 21 at 1940 hours.
Okay, all right, thank you. Ms. Powell, did you have anything to add?
No, Your Honor, I don't have nothing to add today.
All right, thank you. Mr. or Ms. Rihanna, did you have anything to add on the motion?
No,
Okay, all right, thank you. Again, as I indicated, the court is going to issue a written ruling on the motion to disqualify. If I rule against the motion, then the court will issue a ruling with regard to Mr. Powell's motion to dismiss. If I grant the motion to disqualify, then obviously the case will be reassigned to a different judge, and we'll go from there. And so for those reasons, in terms of a status conference, the court will reset this for another status conference once I've been able to rule on those motions, because again, I don't think we can go forward until we have rulings as to both of those things. So parties can expect that they will receive the written opinions from the court here shortly. I guess I do want to, Mr. McPherson, have you been receiving the court's documentation, Mr. McPherson? I'm assuming you've been appearing for everything, so I'm assuming you're getting our notices, so we're sending them to the right address.
Yes, everything listed on the court papers is 710 Willard Avenue is where my court papers should go to.
Okay,
And
all right.
I have property all over the country, so I got addresses where I receive mail periodically, parts of the year. So,
And that's great, but we need to know where to send your stuff.
yeah, that 710 Willard Avenue, which is written on that court paper, Your Honor.
Okay, very good. Thank you. All right, that's all for the hearing today. All parties in this case are free to disconnect at this time.
Your Honor, one before we go, I had the sheriff's department out at my house September 8th in regards to Mr. and Mrs. Guyana's daughter, Tracy Guyana, saying I was trespassing by using the easement. I just wanted to put that on the record again. We're still having these issues with calling sheriff's departments on myself for using deeded access and easements as well. So please take that in consideration as well.
That's really not going to be relevant to these motions. So that sounds like that's something that's occurred. So.
Yep. Thank you.
Thank you.
Excuse me, Your Honor, are we ready to go? All right, can we leave?
Yes. Yep. Everybody's free to disconnect. Sorry.
Thank you, sir.
Okay, sorry about the delay there, council. I had two hearings set for 1:30 and the first one took quite a bit longer than I anticipated, but we'll go on the record. This is IRT Commercial Services versus Cash and Carry, case number 2218977. If I could just have council put your appearances on, please.
David Svengros for Westwind and for Gaylord Opportunity Fund.
Your Honor, Greg Light on behalf of Margaret Lee and Christopher Lee.
Rick Conklin on behalf of Commercial Distribution Specialists.
All right, thank you. This is set for a status conference today. I know obviously last month we had motion hearings in this case. Just in terms of how to go forward from here now that we've got orders entered based on the court's rulings on those motions. I'll just start with Mr. Svengros. Where do you see us being at this point, or where do we need to go going forward?
Well, I think and council can disagree with me if I've forgotten something, but I think the claim of Westwind against Lee still exists. And I believe there is a claim between Westwind, Gaylord, and SRS Willoughby, Mr. Conklin's client.
Yes, that to my recollection is correct.
Yep.
So I don't know. I'm assuming that there hasn't been, just because of the posture of this case, that there hasn't really been any kind of mediation or anything. Is that something that you guys want to look at?
Well, I think the case started with mediation, as I remember. We had mediation before we did anything. And it was very fruitful. You might have something.
Well, it
Yeah, I mean, now we're in a completely different spot than back then. I mean, does anybody have any objection to setting aside a period for the parties to engage in a facilitation?
that sounds appropriate to me, Your Honor.
I think so too.
I agree.
Maybe if you give us 90 days to do mediation, and then we can all talk in that period of time. I know, at least from my client's perspective, we do have judgments against Mr. Collins and against the company. I don't know. He hasn't been responsive to anything. I don't know if he's working or anything. And, perhaps Mr. Light might have some information for us from his client. I don't know what the status of IRT is either, if your client has taken it back. And I guess that's something we can discuss going forward.
Yeah, I can tell you, we don't know. I don't know anything. As far as I know, my clients haven't been in contact with Collins and they have not taken the business back. So I don't know what the status of that is.
Okay. Well, I'll give you a call later in the week and we can talk about some stuff that my client told me, but yeah, we should be able to get something worked out, I hope. And certainly if Collins could come up with the money, this thing would all go away. We can find him. So, yeah.
All right, well, let's say, I'm assuming that you guys would be able to confer and agree on a mediator.
Yes, I believe so.
Okay, so let's set aside that 90 days for mediation. I'm going to ask that the parties agree on a mediator and just notify the court in writing of your selection, let's say within the next 14 days. And then I'll set this for a status conference at the expiration of that 90-day period. And then let's see where we're at that point.
Sounds like a plan.
Does anybody have any other dates that you want to address today?
Not from my end, Your Honor. Thank you.
Nothing from me.
Nothing from me either.
Okay, great. I'll put that into an order. The court will send out a notice of the date and time for that next status conference. Thanks for your patience, and all parties are free to disconnect at this time.
Okay, thank you. Talk to you
Thank
guys.
you, Your Honor.
Definitely talk to you guys later. Thank you, Your Honor.
Susie, are you there?
Yes, sir.
You see a petition for expungement on Mr. Grappin. I don't have that on my.
No, that was never never filed. We never did
There
get
wasn't.
that. Yes, sir.
Okay, very good. Thank you.
You're welcome.
Okay, Mr. Kasuba, I'm gonna need you to go into your Zoom app and connect your audio. So if you go into your Zoom app, there should be an option for you to use either to check, use your device's audio or it'll connect to your computer audio. But in order for us to hear you, I'm gonna need you to do that. Okay, and then I just need you to unmute, please.
Pardon?
There we go. Okay. Are you able to hear me?
Yeah, I can hear you.
Okay, and just to make sure, you're Timothy Kasuba, is that correct?
Yes, I am.
Okay, Mr. Kasuba, I have this set for entry of a judgment of divorce today. Is that how you wanted to proceed?
Yes, it is, Your Honor.
Okay, I'm going to place you under oath, and I've got some questions that I need to ask you. These are the questions that I'm required to ask to establish the grounds for divorce under Michigan law, okay?
All righty.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand. Mr. Kasuba, you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yeah,
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
what was that now?
At the time you signed the complaint for divorce, had you been a resident of the state of Michigan for at least 180 days?
Yes, I've lived in the state of Michigan, yes.
Okay, and had you lived in Otsego County for at least 10 days?
Yes, I have, sir.
In the complaint, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that your marriage could be preserved. Was that true when you signed the complaint?
Yes, it is, sir.
Does that remain true today?
Yes, it does.
And there are no children that were born to the marriage or adopted by you that are under the age of 18, is that correct?
That's correct.
To your knowledge, is Ms. Kasuba currently pregnant?
No, she is not.
In the proposed judgment of divorce, there's a statement that indicates that you're not going to receive any spousal support or alimony, is that true?
Nope, I do not get any child support or anything like that because we don't have any kids to do that with.
Okay, but you're also not going to receive any alimony or spousal support from Ms. Kasuba, is that correct?
That is correct, sir.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes, I do.
Have you already divided up all the assets and debts of the marriage with Ms. Kasuba?
Yep, we got what we wanted and that's what we have.
Okay, and do you own any real estate or real property together?
Nope.
Okay. All right, the court finds that the statutory grounds for divorce have been met by the testimony of Mr. Kasuba. I reviewed the file. Ms. Kasuba was properly served with the summons and complaint. She did not file an answer. She was defaulted back in August and provided notice of the date and time of today's hearing, which was 2/15. It's now 2/23. She has not appeared, so the court will grant the divorce. And I'm signing that judgment of divorce with today's date. And Mr. Kasuba, you can get a copy of that here at the courthouse if you need that for your records, okay?
Yes, thank you, Your Honor.
Did you have any questions at all?
No, that's it.
Okay, thank you. That's all for the hearing today, and you're free to disconnect at this time.
All righty. Thank you, Your Honor.
Thank you.
Have a good day.
Thank you. You as well. Mr. Benzinger, are you able to hear me okay?
I can hear you. I don't know what's going on with my video. There you go.
All right. This was set for a pretrial at 2:15, and I do not see opposing counsel in the Zoom waiting room. Have you had any contact with them leading up to today?
I did. I talked to him, I want to say maybe a week ago. Nothing about the pretrial though.
Okay. Unless you have an objection, I would just reset this. Maybe there's some kind of communication error or something, but I would just reset it for another 30 days unless you have any objection to that.
Sounds good.
Okay, all right, the court will send notice of the date and time of that hearing, and if you happen to talk to opposing counsel, just let them know, you know, we were on the record and
Sounds good.
ask him to appear next time.
Got it. All right, thanks.
Right. Thank you, that's all for today. You can disconnect, thanks. Okay, Mr. McPherson, are you able to hear me?
Yes, sir.
Thank you. Mr. Chasm, are you able to hear me?
Yes, Your Honor.
Okay, we're on the record in McPherson versus Nowicki et al. This is case number 22-19171. We have Mr. McPherson present on behalf of himself as plaintiff. Mr. Chasm is here on behalf of the all defendants. We have two matters up for hearing today. We have Mr. Chasm's motion for summary disposition, and then we have Mr. McPherson, I believe in this case as well, you filed a motion for disqualification, is that correct?
Yes, Your Honor.
Okay, so Mr. Chasm, I've had one previous hearing in Mr. McPherson's file, so in a separate file, so he already knows this, but my plan for today is to hear arguments as to both motions and then issue a written ruling. Because the motion for disqualification obviously needs to be decided first by the court. And then if the court grants that, the case would be assigned to a different judge. If the court denies it, then I would then move on and issue a written opinion as to the motion for summary disposition. So Mr. McPherson, again, I know you've already addressed this in the previous file, but we're going to need to do it in each of your cases this afternoon. So that Mr. Chasm has an opportunity to respond. Was there anything that you wanted to state for the record in support of your motion for disqualification?
Yes, Your Honor. We have, there seems to be several issues regarding the personal protection orders in Mr. Chasm's answer or summary disposition, which you're going to be a witness in. I think I alluded that to the last time we were in status conference hearing. I also filed a motion that was rejected earlier in the month to the clerk's office. It was filed incorrectly, and we apologize for that. And then we've also, a lot of the officers involved, it's around personal protection order that's been issued from you, yourself. And then land use, some of the land use issues are land use putting a building in our easement or close to it, which also had issued a personal protection order to those individuals. And with that building being placed 6 feet from the roadway, and us having to argue with the county for 2.5 years on moving that building, there was a interference with land contracts, and there's another PPO that's interfering with our access to other land contracts that we want you to speak on and testify. And any answer to the summary disposition would taint your testimony. And that's why there isn't any answer to the summary disposition right now. And we would, once it's issued to another judge, we would gladly submit that and move on. And then also on there, part of the case revolves around Mr. Chasm had already sent a letter admitting to a zoning violation. And per the county policy, Mr. Chasm and his attorneys or attorney firm, the county attorney is supposed to represent me as a victim of zoning violations in these matters. So we kind of have a conflict of interest going around with the county attorney and who they're supposed to represent and yada, yada, yada. So we're just lost, Your Honor. And we think if we move on with a different judge, that we might be able to rectify some of these situations.
Okay, thank you. Mr. Chasm, was there anything that you wanted to state as to the motion for disqualification?
Thank you, Your Honor. Yes, first of all, for the record, I am going to ask that it be stricken because it was not properly served. I received the motion to disqualify this afternoon. And by the proof of service that was filed with the motion, it was served via first-class mail on September 28th. So my first objection is based upon MCR 2.119 C1, which requires that any motion be filed at least 9 days prior to the date of the hearing if it is being served by first-class mail. That's my first objection for lack of proper service. My second basis to respond to this motion is that it's untimely pursuant to MCR 2.003 D1A. The court rules require that any motion for disqualification must be filed within 14 days of discovery for grounds to disqualification. And even a cursory review of this motion makes it very clear that all of the allegations stated in this motion were known to the plaintiff well in advance of the 14-day requirement. In fact, based upon the allegations which date back to 2020 and 2021 and 2022, all of those alleged basis for disqualification were known to the plaintiff at the time that he filed the lawsuit. And in fact, if we go back to some of the transcripts from the status conferences that have been held in this case, in addition to the motion for preliminary injunction that was filed by plaintiff, he had previously threatened to file these motions, but never did. So the fact that this motion is literally being filed or was filed in the 11th hour, that when we filed a motion for summary disposition, instead of filing a response to it, he filed this particular motion. It is a clear evidence of dilatory tactics and a blatant attempt to prolong these proceedings unnecessarily. With respect to the actual merits to the motion, the case law is very clear. It is there's a presumption of impartiality as to a trial judge, and based under Kane versus Department of Corrections 14451 MISH 470 1996, a trial judge is presumed to be impartial, and the party who asserts partiality has a heavy burden of overcoming that presumption. So nothing in the motion has met that standard for the plaintiff. A showing of prejudice usually requires that the source of the bias be in events or information outside the judicial proceeding. Everything in this motion is based upon judicial proceedings, personal protection order violations, primarily those, and any other legal proceedings. And again, the case law in re contempt of Henry 282 MISH App at 680 Court of Appeals decision states that disqualification on the basis of bias or prejudice cannot be established merely by repeated rulings against a litigant, even if the rulings are erroneous. And clearly, the entire basis of this motion are this court's rulings on PPO matters. And finally, again, with a very preliminary and cursory review of the 86 pages or 52 pages, I believe I received this afternoon, the plaintiff has attached a transfer from I believe a PPO hearing from August of 2021 in support of his allegations that the court made some remarks during one of those proceedings. And in Schellenberg versus Rochester Elks 228 MISH App 2019-98, the court stated that a trial judge's remarks made during trial, which are critical of or hostile to counsel, the parties, or their cases, ordinarily do not establish disqualifying bias. And nothing in those statements suggested any degree of hostility or bias. So again, this is very preliminary because I did not receive this motion until this afternoon. I believe there's absolutely no basis in law or fact for to disqualify you or any other of the judges as is requested. And finally, to the statement made that somehow as the county attorney, there's a conflict because I have a duty to represent him. I don't think that even deserves the dignity of a response because it is so frivolous and nonsensical that that I don't believe that I need to even respond to that. Thank you.
All right, so again, I'll issue a written ruling with regard to the motion for disqualification. If that's denied, I do want to get the parties' arguments as to the motion for summary disposition. I did review your brief, Mr. Chasm, as Mr. McFerrin indicated, he didn't file a written response. But Mr. Chasm, anything that you wanted to state in terms of oral argument in support of your motion?
No, Your Honor. I mean, due to the fact that the court has just indicated that it has read my brief and motion, and there essentially is no response, so there's no rebuttal to any of the arguments that I could address at oral argument. The defendants at this point are going to stand on their briefs filed with the court.
Thank you. Mr. McFerrin, was there anything that you wanted to state in opposition to Mr. Chasm's motion?
Yes, Your Honor. Without having an answer filed by Mr. Chasm, we're limited on the direction of how his oral arguments or his arguments for your recusal are going to be. So that's why we're limited. We met within the 13-day or 14-day threshold. By the time I was served with those paperwork from him, I finally now knew where his argument was going to go, and it went exactly right to the personal protection orders and using the adjudicated matters, where I do believe in one of the instances you found me guilty based off my body language. And so once again, we ask that you would recuse yourself from this trial, for one, that you're going to also be a witness for myself as well. So.
Okay, but I'm talking about the motion for summary disposition that Mr. Chasm filed, that we have a hearing for today. You indicated you didn't file a written answer to that. Do you have any oral argument that you'd like to make in opposition to it?
Correct. I've read some of it. Factually, it's wrong. Mr. Chasm says it starts in, our instances start in 2020, and Mr. Chasm was issuing zoning violations back in 2019 to Mr. Guyana's that they had placed incorrectly cited building, and by default into the easement. By default, the county policy is that I'm entitled to damages and representation by the county attorney, and that's 25.1 of the Otsego County zoning policy, which is very clear, unless they're referring to the county attorney as the prosecutor's office. But Mr. Chasm has never represented me, and he should by default from what the law states. So I'd like to put that on the record, Your Honor.
Okay, all right. Anything else with regard to his motion for summary disposition or the grounds for it?
Any questionability about me and zoning, I just reflect to our past case where I had to sue Mr. Chasm in the county in small claims in 2018. And then come to find out in 2019, I was right, and by the letter that Mr. Chasm sent, and that it's included in that motion as well, Your Honor, in that packet I sent in those 55 pages.
Okay, thank you. Mr. Chasm, any response to Mr. McFerrin's argument?
No, Your Honor, I can't even make head or sense of what the argument is, so no.
Okay. All right, the court, as I indicated at the beginning of the hearing, the court will first issue an opinion as to the motion for disqualification. If the court grants that motion, the case would be reassigned to a judge. If the court denies it, then I will issue a written opinion on the motion for summary disposition. Parties can expect that forthwith.
Your Honor, before we go, does Mr. Chasm dispute that I was a victim of a zoning violation?
I have no idea. That's something you can call him and talk to him about later if you want.
Yep. Well, I'm just, because I'm getting one thing from my county commissioner and I'm getting another thing from Mr. Chasm. And so I'm just confused on where we're supposed to go.
Yeah, I would give Mr. Chasm a call and talk to him about it.
Thank you very much, Your Honor.
Okay, all right. Thank you. All parties in this case are free to disconnect at this time.
Thank you, Your Honor.
Thank you, Your Honor.
All right, Ms. Hessenthaler, were you expecting any other counsel to be joining in on this hearing today?
I don't believe I was, Your Honor.
Got one other person, sure. Got Edward Lucas, sir, can you unmute and, sir, what case are you appearing on today?
Yes, sir, I can unmute. Can you hear me?
Yes. What case are you appearing on?
Case number. Case number 2023 000019307-DO.
I'm not seeing that on my docket. Are you sure? I'm Judge Mertz. Are you supposed to be in Judge Mertz's courtroom?
245. Yes, it is.
You are directed to appear as follows. Date Monday, October 2nd, 2023. Time.
That's the old one.
It was originally scheduled for 3:15 and then it was moved up to 2:45, Your Honor.
Still not seeing that. I'm just going to put you on hold for a minute and we'll see if we can find out where the discrepancy is, okay?
Yes, sir.
And is it Lucas versus Lucas? Is that the title of the case?
Yes, sir.
Okay. All right, just hold on one second. Susie, if you're there, can you take a look at that and see where our discrepancy is? Okay, Ms. Hessenthaler, we'll go on the record in your matter. That's Caterpillar Financial Service versus Stuffman Tree Service, case number 2118434. If you want to put your appearance on the record, please.
Thank you, Your Honor. Good afternoon. Emily Hessenthaler, appearing on behalf of Caterpillar Financial.
Okay, this is your motion to reinstate the case and enter a consent judgment. It looks like you had a stipulated order signed by defense counsel. Is that correct?
Correct, Your Honor.
Okay. Was there anything that you needed to state for the record then today in support of your motion?
Thank you, Your Honor. Just that the party pursuant to the party's settlement agreement, they agreed that the defendants would owe the settlement amount of $250,000 subject to the specific payment plan. And that if the defendants failed to make any of the payments subject to that payment plan, that Caterpillar Financial would serve its notices of default to the defendants, and that following a 45-day cure period, if the account was not brought current, that Caterpillar Financial would present its affidavit of default to the court and present the consent judgment for entry at that time. Defendants have failed to make any payments since about August of 2022. Caterpillar Financial served its notices in December of 2022, and it's been well past that 45-day cure period, and the account was never brought current. So accordingly, we ask at this time that the court enter the party's stipulated order to reinstate this action and enter the consent judgment in favor of Caterpillar Financial in the amount of $579,810.30, which was the original total amount owed, less the $71,000 that was paid by the defendants to date.
Okay, and I saw the stipulated order that was attached as Exhibit 1. Is that the one? Is that the order that you wanted me to enter?
Correct.
Okay, I did not see a consent judgment though, and I don't know if that was something that was submitted, or maybe I'm just missing it.
Not sure why that was not. I can make sure that that gets filed as well or submitted.
Okay, so I've signed the stipulated order of reinstatement. And then if you just want to submit that consent judgment separately, then I can sign that. Although it looks like the stipulated order, I mean, it does reference that amount. I don't know if you want to file a separate, scale judgment form reflecting that or not.
Yeah, it seems as if actually, yeah, it's a sort of incorporated. So I don't know that we will, if that's all right, I'm not sure that we will need to submit a separate consent judgment for that.
I'll leave that up to you. I've signed the order that was presented. Anything else that we need to address on this file today?
That will be all.
Okay, thank you. You're free to disconnect this time.
Thank you. Have a great afternoon.
Thank you. Okay, looks like we've got everybody connected. We'll go on the record in Crowell versus Crowell. This is case number 2319376. If I could have counsel put your appearances on, please.
Good afternoon, Judge Elliott Blumberg on behalf of the plaintiff Melanie Crowell, who is appearing via Zoom from my office.
Good afternoon, Your Honor. Mark Dundon appearing on behalf of defendant Todd Crowell, who should be appearing via, I believe.
Yes, and Mr. Crowell is present by Zoom as well. I believe this is the first hearing in this case. We're set for a pretrial scheduling conference today. And let's see, Mr. Blumberg, on behalf of plaintiff, can you tell me where things are at so far and what you'd like to see for scheduling going forward?
Sure, Judge, the parties have not yet finished turning in their verified financial statements. So we have a pretty good idea. There are two major pieces of real estate that need to be divided up in this matter. There's some retirement accounts. I think the normal maybe 90 days for discovery should be sufficient. I think Mr. Dundon and I talked about the parties going to mediation with a professional mediator. So I don't think there's anything extraordinarily different in this case. So I think 90 days should be sufficient.
Thank you. Mr. Dundon?
Agreed, Your Honor.
Okay. So we'll set it for a period of 90 days for discovery, mediation to occur within that time. And then the court will set this for a status conference pro-con shortly after the expiration of that 90-day period. The parties have been able to reach an agreement, then we can use that date to enter proofs. If not, we can see what kind of issues are left and conduct further scheduling at that time. Any objection to that, Mr. Blumberg?
No, Judge, that seems reasonable.
Mr. Dundon?
No, Your Honor.
Okay, Mr. Blumberg, anything else on behalf of your client today for scheduling?
Judge, I guess, and I've mentioned this to Mr. Dundon, I think we would like to maintain the status quo where historically both parties have deposited their paychecks into a joint account from which all the bills were paid. We would simply expect that to continue.
I just spoke with my client, Your Honor, after I spoke to Mr. Blumberg. He's fine with that.
Okay. All right, Mr. Dundon, anything further from your side then?
No, thank you, Your Honor.
Okay, I'll put what we've discussed today into an order, and then the court will send out notice of that next hearing to the parties, and we'll go from there. All parties on this case are free to disconnect at this time. Thank you.
Thank you, Judge.
Okay, Mr. McPherson, are you able to hear me okay?
Yes, Your Honor.
And Ms. Guyana, are you able to hear me okay? So Ms. Guyana, I'm going to need you to connect the audio on your Zoom app.
Your Honor, you can hear me, correct?
I can, yes. It looks like Ms. Guyana's having some issues connecting her audio, so I'm just gonna give her
No,
another minute or.
no worries been there, Your Honor.
Okay, Ms. Guyana, are you able to hear me now?
Yes, I am. Sorry.
Okay, thank you. All right, we're on the record now in Aaron versus Guyana. This is case number 2319325. The record should reflect both parties are present today by Zoom video. We have two matters up for hearing today. Mr. McPherson, we have your motion to disqualify the court, and then Ms. Guyana, we have your motion to dismiss. Mr. McPherson, I know you've done this a couple of times already this afternoon, but is there anything that you wanted to state for the record on your motion to disqualify?
Your Honor, I don't believe there's a motion to disqualify yourself in this case. I think it was just in the other two. I think we'd already set this for mediation.
Okay.
And you already set a couple of dates a couple of weeks ago. And
Okay.
I was still under the impression we were hoping we were coming to a record, something we could come up to something in mediation, and there would be no need for it to delay the court's time.
All right, okay. I thought you filed them in all three files, so that's fine. We won't go forward with that part of it then. Ms. Guyana, was there anything that you wanted to state today in support of your motion to dismiss?
Yes, there is, Your Honor. I don't understand a lot of what's going on in this case. The first thing that's bothering me the foremost is being Mr. McPherson stating that I have been charged with making fraudulent police reports, falsifying police reports, which this has never happened in Otsego County or anywhere else in the state of Michigan or in the United States for that fact. I've never been charged with anything. I'm considering this to be slander. I sent you over the copies of what I have. I do also have another piece of evidence that I've not yet had the chance to submit. I have a letter from Otsego County stating that I have never been charged with falsifying a police report, nor have I been held in any Otsego County jails, and nothing of that nature for what Mr. McPherson is stating that I have done.
Okay, anything else in terms of your legal basis for asking to have this lawsuit dismissed?
No, there is not, Your Honor.
All right, thank you. Mr. McPherson, anything that you wanted to say in opposition to the motion?
I think the date that Ms. Guyana is referring to is in late August of 2020. There was a police report I did submit to several other cases for you to recuse yourself. We had Miss Guyana had called she claimed that I had shot her in the face with a rubber band of some sorts, according to the police reports. And I guess out of my car or something on an easement, but I keep dash camera and security cam footage at the house. And when the officers viewed it after I come back home about an hour later, they ended up giving me a victim service card. And in the police report, it says false police report / PPO violation. And then I was never charged with the PPO violation. It was never brought up in your court. It was never mentioned. And then we never heard from Miss Guyana again. She never brought up another PPO claim until the following year. She let her personal protection order die. But that's the police report that I'm referring to. It was Sergeant Fox, I do believe, and I submitted all the dash cam, the cell phone video, or the dash cam and the security camera footage. It's all time date stamped. And I sent that to him 15 minutes or at the scene or 15 minutes afterwards. So that's where that comes from. But
Okay, thank you. Anything else that you wanted to say?
no, Your Honor. Other than the fact that, like I said, we thought this was scheduled for mediation. I've been talking with Annette at mediation as far as scheduling dates. And then I do believe this motion was sent to the wrong address. Or no, I think that one was sent within I think 7 days of the court date today. So I think I just got it last Friday, Thursday or Friday. So as I've told the courts before, I am not, I'm in the process of moving out up there, and that's where I do not receive my mail. So if we could just have it sent to the Ohio address, if Miss Guyana could, and then let's hope we come to some agreement and mediation. And then one other thing, Your Honor, several weeks ago, the sheriff's department was out at my home, and via my Ring camera, I was alerted to Officer Bragg, in which he was notified by Miss Guyana, who was somewhere down in Detroit, that I was trespassing on her property. And I guess it was a picture of me in my car using Screaming Eagle Pass. And so Mr. Bragg just said, okay, I think the sheriff's department has come into a realization of where the easements are and who has access and what has access. So I just wanted to put that on the record as well, Your Honor.
Okay, thank you. Ms. Guyana, anything you wanted to say in response with regard to your motion today?
Yes, there is. As far as what Mr. McPherson just stated about September 8th, I was not in Detroit. I was in Otsego County. And I have a camera that alerts my phone, and it is on the property. It is not in any easements. He pulled up in front of our no trespassing sign, which is far into the property line of my father and my stepmother. And the camera took a picture of his vehicle. And I brought that picture to Otsego County Sheriff's Office, and I asked him which way I should proceed. Then I got a phone call from Mr. Braggs when I came back home. And he told me that he was going to contact Mr. McPherson in regards to trespassing, that he's seen the post that I indicated that the property owner had put up that is supposed to be where the easement lies. And he was on the property, and that's all I have to say about that. I mean, but as far as this police report that he's referring to, I have never been contacted in any which way or form by anybody in regards to this police report. It wasn't a rubber band that they proclaimed shot me. I stated that it sounded something rubbery, but I didn't know. They have pictures of my face. I don't exactly know what I was hit with, but that's, I don't know what else to say in this matter.
Okay. All right, the court is going to issue a written opinion ruling on the motion, provide that to both parties, and then the court will set this for a hearing following that. That's all I have for today, and both sides are free to disconnect on this case today.
Thank you, Your Honor.
Your Honor, are we still going through with mediation?
I'm sorry, what's that?
Are we still going through with mediation? I know we were supposed to have mediation within the next 30 days. Do you still want us to go through with that?
It's been ordered, so you should proceed with that as scheduled, yes.
Okay, thank you, Your Honor.
Yeah, thank you.
Bye.
Okay, we've got both sides connected. We'll go on the record in Tronic versus Tronic, case number 2219141. If I could have counsel put your appearances on.
Good afternoon, Your Honor. Mark Dundon appearing on behalf of Leanne Tronic.
Good afternoon, Judge Elliot Blumberg on behalf of Donald Tronic, who's appearing via Zoom from my office.
Your Honor, my client called me. Sorry, I apologize. My client called me last night and thinks she has COVID, so I was hoping we could proceed without her.
Yep, we sure can. On behalf of plaintiff, Mr. Dundon, can you tell me where we're at with this case?
The parties have exchanged quite a bit of information, and Mr. Blumberg made an offer that is getting kind of, we're in the ballpark, but we haven't quite settled the case yet. And I talked to Mr. Blumberg about maybe doing an attorney mediation to see if we can finalize this, Your Honor.
Okay, Mr. Blumberg.
Judge, we're not opposed to that, but I think given the court's schedule, I'd like to get this matter scheduled for trial. I know that earlier today you were talking about at least 60 days before that would likely happen. If we could get a trial date, and then in the interim period, we'll explore mediation. And if we resolve it, great. We'll let you know as soon as that happens.
Agree, Your Honor. That's,
Go ahead.
no, I agree, Your Honor. That would work.
All right, Mr. Dundon, if we set this 60 to 90 days out, is that enough time for you to be ready?
Yes, sir.
How much time do you think we would need?
I would think a half a day to a day. That I believe we've pared down what the issues, I think, fairly well, Your Honor.
Okay, Mr. Blumberg?
I'm sorry, so were you inquiring how long we need to try the case?
Yes.
Yeah, I think we can do it in a day.
Okay, so I'll set it for a 1-day bench trial at 60 to 90 days out. I'll set it for a final status conference prior to that date. And if the parties have been able to reach an agreement, we can use that to enter in pro-con. And if not, we'll have a trial date already set so we can get it resolved one way or the other. As usual, I'll just ask that once we have that trial date, if it doesn't settle, if you can exchange your witness and exhibit list 7 days prior to the trial date, and then provide the court with a short trial brief outlining how you'd like the court to divide up any of the property or assets or debts and the legal basis for that. Mr. Dundon, anything else that I can address for your side today?
No, thank you, Your Honor.
Mr. Blumberg?
No, Judge, thank you.
Okay, thank you. That's all for today, and both sides are free to disconnect at this time. It also concludes the court's afternoon docket. The court will be in recess until 9 a.m.